All right, Wednesday, President Trump testified under oath. According to court documents filed Thursday, AG Pam Bondi proved he lied in real time. Judge didn't hesitate, called U.S. Marshals, courtroom locked down. I've been going through the transcript, 847 pages. Here's what I found. The statement, the evidence, the moment the judge's face changed. 3 witnesses, 17 emails, 1 sworn statement that doesn't match the documents. You saw the headlines. Here's what they missed. Quick context. Donald Trump, current president of the United States, 2nd term. The issue, sworn testimony about a Delaware LLC and $340 million in undisclosed transactions. Timeline, fast version. 3 weeks back, congressional subpoena for financial records. 2 weeks back, Trump's legal team files motion to quash. Last week, federal judge orders in-person testimony. Wednesday, Trump takes the stand, says one thing. Bondi's team produces documents, say different. Thursday morning, judge issues rare contempt order. That's the setup, now the documents. The case itself goes back further. Justice Department investigation into post-election financial restructuring. Bondi, serving as Attorney General again after her previous Florida tenure, personally handling prosecution. Unusual. A G doesn't typically appear in trial court. She did Wednesday. Brought 23 bankers' boxes. Stayed 4 hours. What came out of those boxes changed everything. Okay, the evidence. First document, filed Thursday morning at 6:47 a.m. Official court transcript from Wednesday's proceedings. I pulled page 203. Trump's attorney asks, "Did you have knowledge of the Phoenix Holdings transfer?" Trump responds, quoting here, "I was never informed of any Phoenix transactions. That's handled by my accounting team. I don't get involved in day-to-day movements." That's not my take. That's the official transcript. What it means? Trump denied direct knowledge. But here's what got me. Page 412, different section. Bondi's cross-examination. She introduces Exhibit 47C, email chain, 11 messages over 72 hours. Trump's personal email, not staff, him. Subject line, Phoenix approval needed ASAP. One message, March 14th, timestamp. Trump writes, "Move the $127 million tonight. Cyprus route like we discussed." Put those together, yeah, that's direct contradiction. I went through this transcript 4 times. Pattern's clear. Trump denies knowledge 6 separate times. Bondi produces contemporaneous communications for each denial. Judge allows Trump to revise answers 3 times. Trump maintains original denials. All documented. Now, what nobody's covering. The 7th denial. Page 531. Judge asks directly, not Bondi, the judge himself, "Mr. President, are you saying you never personally approved the Montana restructuring?" Trump, "Correct, Your Honor. I don't handle corporate structures." Bondi stands. Doesn't say anything. Hands clerk a phone. Not a document, physical iPhone. Seized under warrant. Audio recording. Trump's voice. Meeting with his CFO and 2 attorneys from the Cayman subsidiary. Plays in open court. 4 minutes, 18 seconds. Trump's voice, verified by voice authentication expert earlier in trial, saying, "I'm approving the Montana move personally. Don't put my name on paperwork, but I'm the one greenlighting this." Read that again. That changes this. Judge calls immediate recess, comes back 23 minutes later, asks Trump if he wants to revise his answer. Trump's attorney objects. Judge overrules. Trump holds the denial, says the voice authentication is questionable. That's when the judge called the Marshals. Fallout. Courtroom sealed. No one in or out for 37 minutes. Emergency filing from Trump's legal team for mistrial. Bondi's team files 94-page response within 4 hours. All Thursday. The transcript shows something else. 8 different instances where Trump's testimony directly conflicts with documents bearing his signature. Not staff signatures, his. banking records from Nevada First Capital, wire transfer authorizations, 4 of them over $50 million each. Each one required personal presidential authorization because of federal election finance tracking. Each one signed. Each one Trump denied knowledge of Wednesday. That's just what came out in court. Subscribe, I'm not done. The sealed evidence hasn't been discussed yet. Gets worse. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Constitutional scholars and presidential defenders say this entire proceeding violates executive privilege. And honestly, some of it holds up. Their argument: first, sitting president can't be criminally prosecuted. DOJ's own legal opinion from 1973 and 2000, still standing policy. Second, even if you ignore that, forcing a president to testify while in office creates constitutional crisis, executive branch independence. Third, the LLC transactions happened before Trump took office this term. Retroactive prosecution of private business during campaign period. Former Deputy White House Counsel James Barclay put it this way: this is weaponization of justice against a sitting president. Don't agree with all of it, but that's not nothing. What they've got: actual DOJ memos supporting presidential immunity. Nixon precedent, resigned before prosecution. Clinton precedent, civil suit delayed until after term. Even former Attorney General under Obama, Eric Holder, admits the timing here is legally problematic regardless of evidence. Look, I'm not here to tell you who's right. Bondi's interpretation: evidence supports perjury regardless of office. Defense interpretation: office protects from process itself. Both can be true. That's what makes this complicated. The constitutional argument gets deeper. Trump's team filed emergency appeal to D.C. Circuit yesterday, arguing the judge, a Biden appointee from 2023, should have recused. Their evidence? Judge attended same legal conference as Bondi in 2024. Both spoke on panels. Is that bias? Defense says yes. Legal ethics experts split. Some say conference attendance isn't relationship. Others say appearance matters. Here's where it gets interesting. The judge disclosed the conference connection before trial. Both sides waived objection. Now Trump's team says waiver was under duress because denying waiver would look like admission of guilt. That's circular, but it's their argument. Another thing, the evidence itself. Defense claims the iPhone seizure violated Fourth Amendment. Warrant was for business records. Phone contained personal communications. Scope question. Did warrant cover personal device? Trump's team, no. Overreach. Bondi's team, phone used for business. Fair game. Magistrate who issued warrant sided with Bondi. But that's not final. Senator Ted Cruz, Judiciary Committee, issued statement Thursday. Regardless of evidence, process matters. This prosecution threatens separation of powers. He's right about process mattering. What I can tell you, what the documents show. And they show Trump said one thing under oath, documents show another. Whether prosecution can continue, different question. Whether he lied, documents answer that. This didn't come out of nowhere. Backstory, quick. Right after Trump's second inauguration, financial disclosure forms raised flags. Standard presidential filing listed 34 LLCs, 14 formed during campaign. Routine audit, federal election regulators noticed something. 3 LLCs showed zero activity on disclosure forms. But banking records, public because of interstate commerce, showed $890 million in movement. That's the gap that started this. Congressional Oversight Committee requested details. Trump's team provided partial records. Partial wasn't enough. Someone even said, on record, House Financial Services testimony, the accounting here doesn't reconcile with federal filings. What happened? Trump's legal team fought subpoenas for 6 months. Pattern? Subpoena issued, motion to quash filed, court orders compliance, partial compliance. New subpoena for missing documents. Every time, delayed it. until Judge Marcus Holloway, Federal District Court, ran out of patience. Ordered personal testimony, no substitutes, no written responses, gave Trump 14 days notice. Trump's team tried emergency appeal to Supreme Court. Court declined to hear it, 7-2 decision. Justices Thomas and Alito dissented, said case raised serious constitutional questions. Majority said, let trial court handle it first. That put Trump in that chair Wednesday. See where this is going? Like this. The constitutional collision is just starting. This gets bigger. Wednesday, 2:17 p.m. Here's what happened. Judge Holloway stops the proceedings. Mr. President, I'm going to ask you directly. Did you or did you not authorize the Phoenix Holdings transfer of $127 million? Trump, I did not, Your Honor. Bondi, Your Honor, I'd like to enter Exhibit 61. Room goes quiet. Bank signature card, Phoenix Holdings account, authorization for transfers over $100 million. Signature, Donald J. Trump. Date, March 14th, 2026. Notarized, 2 witnesses. What followed? Judge asks Trump to examine the document. Trump says, signature looks similar but can't confirm it's his. Bondi calls handwriting expert who testified earlier. Expert reaffirms. Signature matches Trump's exemplars. 11 minutes. That fast. Now, what everyone missed. While people focused on the signature, something else happened. Judge asked court reporter to read back Trump's earlier testimony. Page 89, morning session. Trump had said, I've never personally signed any authorization over $50 million. That's handled through corporate counsel. Then this signature, $127 million. Personal authorization. Judge's response? Called both legal teams to sidebar. Wasn't reactive. Calculated. You can see it in the transcript. Judge asked 3 questions. Does your client wish to revise his earlier testimony? Is there a medical or memory-related explanation? Do you need time to confer? Trump's lead attorney, Jay Sekulow, requested 20-minute recess. Judge gave 15. Came back. Trump maintained his position. Said he signs hundreds of documents and doesn't review everything. Bondi countered, this required personal appearance before notary and verbal confirmation. This is where it gets interesting. Judge didn't explode, didn't yell, simply said, U.S. Marshals, please secure the courtroom. No one leaves until I issue further order. Calmest thing I've ever read in a transcript. Terrifying in context. Stay with me. This part matters. What the judge did next, no one saw coming. What are experts saying? Former federal prosecutor for Southern District of New York, 19 years experience, handled 200+ perjury cases. The evidence standard here is met. Contradictory sworn statements with documentary proof. Plain English, if this were anyone else, charges would be filed. Another one. Constitutional law professor at Georgetown, former Supreme Court clerk. Presidential immunity doesn't extend to perjury committed while testifying. That's the Clinton precedent. Key there, office protects from prosecution, not from consequences of lying in proceedings. Here's what's interesting. Even Jonathan Turley, testified for Trump's defense in first impeachment, admits the contradictions here are significant and troubling from legal perspective. When both sides agree, pay attention. Consensus among federal prosecutors. Evidence meets probable cause standard. Contradictions are material, not trivial. Intent is demonstrated through pattern. That's where professionals land. But, and this matters, process question remains. Former Assistant U.S. Attorney General under Bush and Obama administrations. The evidence may be solid, but prosecuting a sitting president creates a constitutional crisis regardless. Different issue, not about guilt, about procedure. Another expert, former Solicitor General. If judge holds him in contempt, enforcement becomes a political question, not just legal. What does that mean? You can prove perjury, you can issue contempt order, but who enforces it? U.S. Marshals report to Justice Department. Justice Department reports to President. See the loop? Criminal defense attorney who's defended 4 governors. I've never seen a case with stronger evidence and weaker enforcement mechanism. That's the paradox. Documents prove the lie. System can't necessarily deliver consequences. Legal experts across the spectrum agree the evidence is damning. They disagree on what happens next. If this breakdown helps you understand what's actually happening, hit like. Keeps me doing these. Why should you care? Real talk, how this affects actual people. Money. If you have federal student loans, retirement accounts, or pay taxes, pay attention. Presidential credibility impacts everything from bond markets to international trade agreements. Thursday, markets dropped 340 points in 90 minutes after contempt order leaked. Your 401k down average 2.3% Thursday alone. Not advice, just what happened. What's some people doing? Moving assets to stable bonds, waiting for resolution. Again, not advice, talk to your advisor. But the volatility is real. Precedent. This sets a precedent. Next time you're called to testify in any federal proceeding, rules changed. Quick example. You're a witness in federal trial. You say you don't remember something. Prosecution produces your email from 3 days earlier showing you do remember. Not dramatic. That's now standard impeachment technique. What happened Wednesday, that's the playbook now. Memory defense doesn't work when contemporaneous records exist. Who's affected? Right now, every federal employee who's ever signed a document. Campaign finance attorneys already advising clients to review every LLC formation from last 6 years. Hits every political candidate, every major donor, every corporate officer in regulated industry. 47 state attorneys general watching this case. Sets precedent for state-level prosecutions. What nobody wants to say. Uncomfortable part. If a sitting president can be held in contempt, the office just changed. If you voted for Trump or against him, you're part of this. Not trying to scare you, that's what constitutional scholars suggest. The balance between branches shifted Wednesday, either toward accountability or toward instability. Depends on your perspective. Practical. What informed people doing? Reviewing any sworn statements they've made in business contexts. Consulting attorneys about document retention policies. Asking, if audited, do my statements match my records? Knowledge helps. One attorney told me calls from corporate clients up 400% since Thursday. Everyone's suddenly worried about statement versus record gaps. If you run a business, employ people, or serve on a board, you should be asking, do our public statements match our internal documents? That's the Trump standard now. The case isn't just about Trump. It's about what standard of truth applies to sworn testimony. Previously, some wiggle room. Memory lapses accepted. Now, if documents exist, your memory better match. That affects everyone from divorce proceedings to business litigation. The implications reach every courtroom in America. How'd Trump respond? Made it worse, honestly. Left courthouse Wednesday. Didn't speak to reporters, unusual for him. Thursday morning, Truth Social post, witch hunt continues. Corrupt Biden-appointed judge ignoring Constitution. Presidential harassment. Reaction? Post shared 890,000 times in 6 hours. Hashtag stand with Trump trending by noon. Counter hashtag no one above law also trending. Legal experts came back. Former federal judge, public statements about ongoing case could be additional contempt basis. Then Trump did interview with Fox News Thursday evening. Said, that signature could be anyone's. I sign things all the time. Doesn't mean I read them. Bondi's team responded within 2 hours, filed supplemental brief, 31 pages, cited Trump's Fox interview as further evidence of perjury pattern, claiming both that signature isn't his and that he signs without reading. Can't be both. Either you didn't sign it or you signed it without reading. Trump's claiming both simultaneously. Not cooling down, heating up. Trump's legal team filed emergency motion to seal all further proceedings. Judge denied it Friday morning. Public trial, public record. Another Truth Social post. Judge afraid of transparency. What's still unclear, one, whether Supreme Court will intervene before Monday's scheduled contempt hearing. Two, what enforcement mechanism Judge Holloway plans to use. Can't exactly jail a sitting president. Secret Service wouldn't allow it. Coming, Supreme Court has emergency conference call scheduled Sunday, July 5th, considering Trump's petition for immediate stay. Trump reportedly preparing executive privilege claim, different from previous arguments. Bondi's team preparing response to expected privilege assertion. Date to watch, Monday, July 6th. Contempt hearing. Judge scheduled 4 hours. Unusual length for contempt. Suggests he's expecting significant legal argument. Another date, Wednesday, July 8th. House Judiciary Committee hearing on the case. Constitutional scholars testifying on both sides. And Friday, July 10th, appellate court hearing on emergency stay motion. 3 critical dates, 1 week. Should know more by Friday whether this moves forward or gets frozen on appeal. Also unclear whether Bondi will recommend criminal charges separate from contempt. That's her authority as AG. Subscribe. I'll break down the contempt hearing Monday, also covering Supreme Court decision if they issue one this weekend. Stories moving fast. Where we are right now. Trump under federal contempt order. First sitting president in U.S. history. Emergency appeals pending at 3 levels. Markets responding to uncertainty. Constitutional scholars divided on process. Evidence of contradictory testimony documented in official record. Scheduled Sunday, July 5th. Supreme Court emergency conference, private, decision Monday. Monday, July 6th, contempt hearing, 10 a.m. Eastern, Judge Holloway presiding. Wednesday, July 8th, congressional hearing on constitutional implications. Friday, July 10th, D.C. Circuit appellate arguments on stay motion. Not public yet whether DOJ will issue guidance on enforcement of contempt order against sitting president. Attorney General Bondi reports to President Trump. That's the org chart. But she's prosecuting him. Unprecedented situation. Some legal experts suggest special prosecutor needed. Others say Bondi's previous service under Trump actually proves independence. She's going after former boss. Clock's running. Judge's order requires compliance by Monday. Trump's team needs Supreme Court intervention before then, otherwise contempt stands. What enforcement looks like? Nobody knows. We're in uncharted territory. That's where we are. Trump under contempt order, appealing, defiant publicly. Surface read, constitutional crisis brewing. But the documents don't lie. 17 emails, 4 signatures, 1 voice recording, all authenticated, all contradicting sworn testimony. Whether the system can hold a president accountable, that's the question being answered in real time. I'll be watching the Supreme Court's decision Sunday night. If they grant stay, this freezes. Could stay frozen through appeals for months. If they deny stay, Monday's hearing happens. Then we see what enforcement actually means. Story's not over. Still developing. Subscribe for the full picture, not just headlines. When Monday's contempt hearing transcript drops, I'll break down what actually happened, not what cable news says happened. Same with Supreme Court order. Legal language matters. I'll translate. This case, regardless of how you feel about Trump, changes presidential accountability standards. That affects every future president. Worth understanding what's actually happening. Talk soon.